Good afternoon, everyone. Welcome to today's outreach session for interesting conduct files. My name is Goksugok, and I'm a legal counsel in the Registration, Inspections, and Examinations Division of the Ontario Securities Commission. I work at the Registrant Conduct Team, and today I'm joined by Michael Denishin, who is the Manager of Registration and Registrant Conduct Team at the Registration, Inspections, and Examinations Division of the OSC as well. I will explain in a few moments what the Registrant Conduct Team does. And in today's session, we will present you the facts and takeaways from some of our interesting cases from 2024 and 2025. Before we begin, I would like to provide the disclaimer regarding our webinar. The views expressed in this presentation are the personal views of the presenting staff and do not necessarily represent the views of the Ontario Securities Commission or any of its other staff. The presentation is provided for general information purposes only and does not constitute legal or accounting advice. Information has been summarized and paraphrased for presentation purposes, and the examples have been provided for illustration purposes only. Information in this presentation reflects securities legislation and other relevant standards that are in effect as of the date of this presentation. The contents of this presentation should not be modified without the express written permission of the presenters. At the end of our webinar, there will be time dedicated for questions and answers where we will address your questions. And you may submit your questions throughout the webinar using the question function in the GoToWebinar control panel. We encourage you to submit your questions as they come to you and as early in the presentation as possible, as this will allow us time to consider them. So I think it will be useful to do a brief introduction about what Registrant Conduct Team does. So the Registrant Conduct Team reviews conduct files referred by other teams in the division. These conducts are relevant to the suitability of registration under the Securities Act, and for each conduct file, we recommend regulatory action to the director based on the outcome of our investigation. I will now turn the presentation over to Michael.
Thank you very much, Goksu. So we thought we would answer two basic questions underpinning this presentation. The first is, why should you, as a registrant or other stakeholder, be interested in registrant conduct files? The first reason is to raise awareness about the activities of the Registrant Conduct Team. I think most people understand that the Registration, Inspections, and Examinations Division handles registration applications and carries out compliance reviews. However, it's important to also be aware that where serious misconduct is identified, it can lead to regulatory action brought by the Registrant Conduct Team, such as in the examples that will follow today. Secondly, the tools used by the Registrant Conduct Team might not be commonly understood. They're versatile and they range from terms and conditions to refusals or suspensions. And finally, while no firm gets registered with the intention of engaging in registrant misconduct, it's still valuable to learn about these files because they provide guidance about how to avoid and mitigate the risks of non-compliance with applicable legislation. And after each file that we discuss, we'll talk about the registrant conduct tips. The next set of baseline questions is why the OSC takes registrant conduct seriously. We'd like the capital markets to be inviting, thriving, and secure, but confidence in those capital markets means that the playing field must be level and fairness must be applied across the board. Misconduct threatens the balance of fairness and thereby threatens confidence in capital markets. We also take registrant conduct seriously because of the adage that the most important investor for us to protect is the next investor. Rather than behaving reactively, we can also prevent future harm proactively when we act as effective gatekeepers based on our past experience and based on the facts that are known to us. And finally, and this is a really important point, we believe that it's necessary to take strong action against registrant misconduct in order to respect the efforts of the many good actors who put in the necessary time and resources to engage in effective compliance practices. And I'll turn it over to Goksu to talk about our first case study.
Thanks, Michael. So today we will review 5 conduct files, and the first 2 were published as director's decisions. ST&T Capital Management and Ning Bank. This was a director's decision from April 2024. ST&T Capital Management was registered in the categories of investment fund manager, portfolio manager, and exempt market dealer. And the firm managed portfolios for separately managed account clients, and although they had the investment fund manager registration, they did not operate any investment funds. The firm claimed to have a novel approach to investing through its proprietary accounts, and by that, they had the view that they could market their proprietary accounts to institutional investors. So the firm borrowed a total of $1.3 million from 3 separately managed account clients to fund its proprietary trading. These clients were issued promissory notes, and the purpose of these promissory notes was to increase the amount of the proprietary account to be able to attract additional investors to grow ST&T. And by making their proprietary accounts larger, the firm believed that they could attract more investors. And prior to the deposit of these funds from the loans, the proprietary account held approximately $45,000. The proprietary accounts and separately managed accounts were held at Interactive Brokers. And Interactive Brokers closed all of ST&T's custody accounts because they believed the deposits to the proprietary trading account of the firm was contrary to back then IROC regulations and also against personal financial dealings with clients. Also, there were no conflicts of interest assessments done by the firm. Additionally, borrowing from clients is prohibited under subsection 2 of section 13.12 of National Instrument 31-103. And not only they borrowed from clients through promissory notes, they also sold shares of themselves. ST&T raised $1.9 million in capital from 8 investors, and 2 of these investors were separately managed account clients of ST&T. They distributed Class B non-voting shares, and the purpose of this capital raise was to fund the firm's operating expenses such as renting office space, paying salaries, and etc. And when the firm sold these shares to investors, it did not collect any know your client information, or they also didn't do a suitability assessment. There were also no conflicts of interest assessment. The firm never discussed the risk of these investments with the investors, and they never disclosed the firm's financial condition to the investors either. So the director's decision of April 10, 2024, well, first, staff recommended the firm be suspended, and the firm opposed the recommendation using its opportunity to be heard right, and they made submissions through their counsel in the OTVH proceeding. And the director found in favor of staff and ordered the suspension of the firm. Suspension was made effective in 30 days, and the reason being was that to facilitate an orderly transfer of client accounts to a different registered firm. There was a clear material conflicts of interest between the registrants and the clients when the registrants sold the Class B shares of ST&T and issued the promissory notes. And the director specifically found that these transactions were contrary to the conflicts of interest requirements. The KYC and the suitability requirements also were not complied with. And most importantly, the firm did not comply with the requirement to deal fairly, honestly, and in good faith with clients, which was also contrary to section 2.1 of the OSC rule 31505. So I now turn to Michael.
So I'll briefly go over the takeaways before I turn to the registrant conduct tips. So this isn't the largest file in the world in terms of dollars at issue. However, where there's a total failure of conflict of interest obligations and suitability obligations, there can be serious regulatory consequences, particularly given the enhanced protections around conflicts of interest that emerged through the client-focused reforms, which are now in effect. I also want to point out that the firm took the position that some of these transactions were not being done pursuant to the registration of the firm. But registrant obligations always apply when you engage in dealing and advising if the registrable activity relates to the category in which you're registered. You cannot turn your registrant obligations on and off depending on the purpose of the capital raising. It's also an important takeaway to know that regulators can get timely alerts from gatekeeping reports, such as the one filed by Interactive Brokers. So here are the registrant conduct tips for this matter. If a conflict of interest is material and cannot be addressed in the best interest of the client, it must be avoided. And this is not a term that we're defining narrowly, because material conflicts of interest must be resolved in the best interest of clients. Now, to the extent that firms are expected to meaningfully consider these conflicts of interest in their business, it's important to document these, not only the conflicts of interest themselves, but also the associated controls. So we mean pre-trade controls, post-trade reviews, anything relating to documenting registrable activity. Firms should also consider the ongoing effectiveness of these controls through testing the process regularly. Now, in addition to the controls and testing, adequate disclosure is also crucial. We expect firms to take the lead in addressing any of these material conflicts of interest, and that includes conflicts of interest arising out of the products offered by the firm and the structure through which the firm and its individuals are compensated. And Goksu can now talk about the next file.
Thank you, Michael. Our second case is about a firm called Florence Wealth Management, and this is a director's decision from December 2024. So as a background, this firm was registered since September 2020, and they were registered as exempt market dealer. And it was founded and financed by business partners Vishy Karmadam and Max Go, who also ran a commercial real estate issuer called Forgrowth. And at the time, this was unknown to the OIC. In the past, Mr. Karmadam and Mr. Go had tried to get a new firm registered as a captive exempt market dealer to distribute Forgrowth, but staff was not comfortable registering the firm because of the compliance deficiencies with the prior firm and concerns with their marketing practices. And actually, Florence was initially named as VM Capital, but changed its name to Florence on September 2020. The firm's ultimate designated person informed the OIC that sole shareholder of Florence was Yupan, who was an independent investor found through his network. But in fact, she was Mr. Go's mother. Staff identified the source of the firm's capital as being a holding company whose shares were owned by Ms. Yupan. In the written business plan submitted as a part of the firm's registration application, the firm advised that they would not be trading in or advising in securities issued by a related or connected issuer. The firm also represented that they did not expect to have any relationships that could reasonably result in any significant conflicts of interest. There was no reference to Mr. Karmadam or Mr. Go in the entire application. So registration was granted, and because the OIC was unaware of the connections between Ms. Pan and Mr. Karmadam and Mr. Go. So unbeknownst to RAE staff, as I mentioned earlier, Ms. Pan was Mr. Go's mother, and Mr. Go was a beneficial shareholder of the holding company and therefore an indirect beneficial shareholder of Florence. Ms. Pan didn't provide the capital for the firm, and indeed, it was Mr. Karmadam loaning the capital to her, which was guaranteed by Mr. Go. And Florence sold securities of Forgrowth to the public using its registration as exempt market dealer in making Florence and Forgrowth related and connected. This was contrary to the business plan, where the firm specifically represented to the OIC that the firm would not be trading in or advising in securities issued by a related or connected issuer. Florence began distributing for-growth products in November 2020. That was approximately 2 months after it became registered. And the reports of exempt distribution, which were submitted to the OIC, also did not disclose that Florence and for-growth were connected. So this relationship between Florence and for-growth was not disclosed until June 2022, which was done through Florence's risk assessment questionnaire. And despite not being registered or permitted, Mr. Karmadam and Mr. Go participated in the day-to-day operations of Florence. There was a compliance review of Florence in 2023, where RAE staff discovered the relationship between Ms. Pan and Mr. Go. And to give the appearance that Ms. Pan was more involved than she was, the individuals produced false consulting agreement documentation for Ms. Pan, where in reality she did not provide any consulting to the firm. And also other false investor communications were presented to RAE staff. There were significant compliance deficiencies in this review as well. And as a result, staff recommended that the firm be suspended to the director, and this was resolved in a settlement by way of a joint recommendation to the director. So Florence made the following admissions. First, they admitted that their application for registration was inaccurate. They sold for-growth products without disclosing that they were related and connected to the issuer. They failed to demonstrate the integrity and proficiency required for ongoing registration. And the firm's UDP and Chief Compliance Officer did not charge their respective obligations. As a result, the director accepted the joint recommendation and Florence's registration was suspended. Its UDP and CCO were given bans of 5 and 3 years bans, respectively.
So before I get into the registrant conduct tips, I just want to give everyone participating a reminder that you're welcome to provide questions in the Q&A function through the GoToWebinar software. So registrant conduct tips. It seems to be an obvious point, but in any disclosure to the public, any disclosure to the regulator, we expect that registered firms and individuals be truthful, complete, and accurate. I also want to point out that the business plan that is filed in the National Registration Database is a fundamental component of any registration application. It has to be complete, detailed, and correct, but it also has to be up to date. So to the extent that anyone's business plan changes, such as, for example, moving from a model where you do not trade in related and connected issuers to one where you do, that's an amendment that should be filed using the Form F6, and that has to be filed promptly when aspects of the business plan change, because the business plan is what our compliance review teams use to measure compliance by the registered firm. In this case, Mr. Karamadam and Mr. Guo were not registered. The UDP and CCO of the firm needed to discharge those obligations even if the people who were in fact majority shareholders were behaving non-compliantly or recommended non-compliance. The UDP and CCO were not given a pass just because the majority shareholders counseled this non-compliance. And to this end, we'd like to remind stakeholders that National Instrument 31103 requires an annual report to be submitted by the Chief Compliance Officer to the Board of Directors. The Chief Compliance Officer must also report any instances of non-compliance that create a reasonable risk of harm to a client or to the market, or are part of a pattern of non-compliance, promptly to the ultimate designated person. And now we turn back to Goksu for the next file.
So now I'm going to talk about some unpublished cases, and these files are anonymized, but we will describe them correctly for guidance purposes. The first case is about a firm which was registered as an investment fund manager. So the investment management division of the OIC identified some marketing deficiencies over time about this firm. For example, they used irregular start and end points in their performance data. They used ratings and rankings from agencies which were not designated as rating agencies. There was inadequate disclosure around performance-based marketing as well. And over the last few years, the firm typically responded to the OIC by agreeing to take down any marketing materials with which the OIC didn't agree. And the principals of the firm explained to us that the firm's marketing department was not well versed in securities law and they only had marketing expertise. Because of these deficiencies, there had to be some meaningful changes about the firm's marketing practices. And staff made it clear that the process was no longer acceptable where staff was identifying problematic sales materials and the firm withdrawing these materials subsequently. So staff recommended that the firm must hire a marketing monitor to oversee and review the marketing activities of the firm through whichever medium and before these activities occur. Also, the monitor's mandate included overseeing and reviewing the firm's compliance with Part 15 of National Instrument 81-102, which is about sales communications and prohibited representations about investment funds. The firm was also placed on refilings and errors list.
So what are our registrant conduct tips for this matter? Most importantly, before marketing materials go live, meaning published on the web, disseminated to clients or to the public, a registered firm must review their marketing efforts for compliance. In particular, we think firms need to take care to ensure that there aren't any false, misleading, exaggerated, or unsubstantiated representations in the marketing materials. Whenever a firm uses phrases like the best or number one, you have to be very careful about how that messaging might be interpreted. Necessary context can't be avoided. You can't cherry pick start and end dates, and you must avoid any material omissions that can provide context to assigning yourself a statement like that. We also recommend that registered firms ensure that there are adequate policies and procedures in place that relate to specifically the use and monitoring of social media, and that training on social media and the firm's use of it for business purposes is provided to any employees with access to firms' social media channels or their own in the name of the registered firm. And here's Goksu with the next matter.
So our second unpublished matter is about a firm which applied as an exempt market dealer. This firm engaged in registerable activities. So this firm held itself out as a registered firm while it did not obtain its registration. They also made some contradictory public statements about its relationship with an issuer, including on YouTube and other social media. And at a major tech conference, they included a slide in its presentation that they had the exempt market dealer registration, and this contravened with the Section 25 of the Securities Act, which prohibited holding out itself without registration. It also contravened with the Section 44 of the Act that prohibits untrue representations about registration. And the firm's argument about this was that they submitted the slides to the tech conference administrators months in advance, and they thought that they would obtain the registration before the conference. And additionally, their proposed CCO lacked the necessary experience to satisfy the proficiency requirements. So the Registrant Conduct Team recommended that they should withdraw the application and they could reapply in the future with a qualified CCO candidate. We also pointed out that a consultant could be helpful in creating a specific plan to address the issues that we identified. There would be no refusal on the record if the firm withdrew its application in good faith, so the firm withdrew its application.
Okay, so the registrant conduct tips. It's really important that you never make any representations that either you are or will be registered until the application is granted, right? So first of all, there's a specific requirement in Section 44 of the Act that you can't make that representation, it's prohibited. But secondly, like Goksu said earlier, Section 25 prevents firms from not only engaging in the business, but holding themselves out as engaging in the business of trading or advising without appropriate registration. Now, in this case, the firm did not have a suitable CCO candidate. We consider registration to be a first compliance review. And in particular, when a firm comes in for registration, we want to make sure that the firm is in a position to succeed with its compliance function on day one. So we recommend that firms consider obtaining high quality professional support to determine whether the proposed chief compliance officer candidate is likely to qualify in terms of proficiency, and whether appropriate compliance supports are in place once the firm begins engaging in registrable activity. We've issued a staff notice. It's CSA Staff Notice 31356. This is not just an OSC document, it's on behalf of the entire Canadian Securities Administrators. And this provides guidance on compliance consultants, both in terms of the services that compliance consultants can provide, and to the extent that terms and conditions are imposed requiring firms to retain a compliance consultant, it gets into the criteria that we will consider before approving or not approving someone to act as the compliance consultant. To the extent that you have questions about whether a proposed chief compliance officer is eligible for the category sought, please provide as much information as possible, and we will share any non-confidential concerns that we can. Obviously, we need an application to be filed because that authorizes us to do appropriate background and detriment checks. But to the extent that you have any questions about whether a certain type of proficiency or a certain level of experience is enough, please feel free to call RIE and we will do our best to help guide you down the right path. Here's the next matter.
Now I'm going to talk about an individual application, and this application was refused, and it was a dealing representative in the category of exam market dealer. So this applicant reapplied for registration after being terminated for cause by their previous employer. And the reason was that they had some personal financial dealings with their colleagues. They also did not comply with certain financial transaction procedures in their previous firm. So in their application, the applicant did not disclose the prior termination for cause. And during our voluntary interview with the applicant, when we inquired about the history of borrowing from their colleagues, they told us that their financial condition was improving. And through our investigation, we identified that in reality, the individual had severe financial challenges and that they would be filing for a consumer proposal, which subsequently happened. The applicant had a number of significant debts arising from gambling losses and poor financial decisions. We constantly are of the view that when an applicant lacks solvency, there is a risk that the individual might engage in self-interested activities. And in this case, our concerns arose from the active consumer proposal and the significant debts. And because of the applicant's active consumer proposal that required a substantial payment to the creditors, and also the circumstances surrounding this significant debt, we had concerns that the applicant could engage in self-interested activities at the expense of their clients. And we also had integrity concerns as well, because the applicant did not provide an accurate description of the extent of their indebtedness, and they also withheld that they were considering making a consumer proposal, which ultimately they made. And secondly, the applicant acknowledged that they knowingly failed to disclose their termination for cause to their new proposed sponsoring firm and in their application as well. And as a result, the Registrant Conduct Team thought that the applicant had not demonstrated the requisite integrity, proficiency, or solvency for registration. So we recommend that the individual's registration be refused and the firm withdrew the application before an opportunity to be heard was requested.
Okay, so that was our final file that we're going to talk about. So here's the last round of Registrant Conduct Tips. I'm going to put in one more plug now to put questions into the Q&A function on GoToWebinar, and we'll get to the questions that we can. Okay, Registrant Conduct Tips. How does this apply to stakeholders on this call? Well, first of all, it's important to carefully review any questions on the Form F4 with applicants. Go over with it carefully, make sure that applicants understand the questions and are answering it correctly, completely, and accurately. Where you flagged financial concerns as part of your due diligence, please always inquire as to whether a near-term insolvency event is a possibility, because the registration staff, when they do their due diligence, will consider the solvency of the individual. It's also helpful to remember that as a registered firm, you're the first line of defense as gatekeepers. And if you learn of detrimental information that was not disclosed by the individual up front, it's always open to you to withdraw the application rather than putting this application toward the staff if it's an individual or a fact pattern with which you yourself are not comfortable. And finally, this is a little bit tangential to the facts of this matter, but if you're asked by regulatory staff about individuals formally sponsored by your firm, please provide that information promptly, because the shoe may well be on the other foot soon, right? Your firm might benefit in the future from the prompt cooperation by another former sponsoring firm of your applicant.
So there are a number of resources available if you want to learn more about registrant conduct concerns, and these are some useful links in this slide that you can just check out.
We'll give you a moment to jot these down if you like.